with the introducer's opening statement. After the opening statement, we will hear from supporters of the bill, then opposition, and followed by those speaking in a neutral capacity. The introducer of the bill will then be given an opportunity to make closing statements if they would do so. We ask that you begin your testimony by giving us your first and last name, spelling those for the record. We will be using a 3-minute light system. When you begin, it is green. 1 minute left will be yellow. And when it's red, we will ask you to wrap up your final thoughts. I would like to remind everyone, including senators, to please silence or turn off your cell phones, put them on vibrate. Just so you guys know, on Thursdays, I have a commitment back in Omaha around 5:30, so I will be leaving Thursdays a tad early, but I will be listening to it on my ride home. So we'll start today with LB 914. Senator Cavanaugh, welcome to Judiciary.
Thank you, Chairman Wayne. Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Senator John Cavanaugh, John Cavanaughh, and I represent the 9th Legislative District in Midtown Omaha. I'm here to introduce LB 914, which would adopt the Uniform Unlawful Restrictions in Land Records Act. But it's sadly a fact of our history that for many years, well into the 20th century, home sales were commonly restricted on the basis of race, until the Supreme Court ruled in Shelley versus Kramer in 1948 that enforcement of racially restrictive covenants were unconstitutional, and the Federal Fair Housing Act of 1968 explicitly prohibited the practice. It was commonplace for a deed to contain language that said a home could not be sold to people of certain races, usually Black people. This practice contributed to generations of housing segregation. Despite the fact that these covenants are now illegal under the Constitution, federal and state law, they remain as a historical artifact in deeds. Last session, I introduced LB 186 to address this and allow for removal of such language from the deeds. I modeled the legislation after an Illinois law, and in the last 2 years, many other states have adopted similar legislation. Over the summer, the Uniform Law Commission considered and ultimately approved the Uniform Unlawful Restrictions in Land Records Act. Larry Ruth, a Nebraska representative to the commission, approached me about introducing the Uniform Act because of my work on LB 186. I think that LB 914 is potentially a better way to address the problem than LB 186. LB 914 will allow for an amendment to make clear that such restrictions are unlawful and no longer enforceable. One concern that has been brought up about simply removing the offending language is that it may damage the historical record of housing discrimination and redlining. The Uniform Act takes this amended approach in order to effectuate a removal without destroying the historical record. It also allows the amendment to be recorded in a simple and efficient manner, decreasing the strain on county resources. LB 914 is a small step toward correcting a historic injustice. I ask for the committee's support, and I would be happy to take any questions at this time.
Any questions from the committee? Seeing none, thank you for being here. First up, proponents. Any proponents? Welcome.
Good afternoon. My name is Larry, Larry, last name Ruth, Ruth. I am a member of the Nebraska Uniform Law Commission, and I'm here today to testify in behalf of support of LB 914. Just a few minutes about what is the Uniform Law Commission. The Nebraska Uniform Law Commission is similar to small uniform law commissions in all of the states and jurisdictional territory. Then these state uniform law commissions also belong to something called Uniform Law Commission, making it a little bit confusing. But we are a state agency, and we do our work with all of the states, sort of in cooperation with them. The Uniform Law Commission of the states, so to speak, is over 100 years old. We, I know, are more at least 60 or 70 years old, because I've gone back in the records and seen some old uniform laws. The point is this: as the practice of law and the history of the country developed, it was quite apparent there were sometimes advantages to uniformity of state laws. And so there were informal arrangements made between the states where they would look at it. This became regularized in such a way that the states all adopted in their statutes a uniform state law for their state, the commission. And we did that in Nebraska. We have over 100 uniform laws in Nebraska jurisprudence right now. I brought it with me, but a little volume 6 of those red books that you have in your office, it's all the Uniform Commercial Code, which is perhaps the best known of the uniform laws that we have adopted and which anybody has adopted. Over the years, the state, the Uniform Law Commission, and others have looked at such things as all of the business law that we have in our state, procedural law, probate law, law that relates to children, domestic relations. And this one here is one that we've selected recently because it's more of a continuing problem that we have. Although these restrictive covenants were deemed unconstitutional by the Supreme Court, they live on. They are in the chain of title of a house, and they can't be enforced, but they're lying there. They're embarrassing to owners sometimes. They are misunderstood because somebody reading it might say, well, gee, I can't sell this to a black. You need to have some way to get that repaired. The states were kind of all over the place as to how they did it. Some states, yes.
Dr. Ruth, I'm sorry. Or
Thank you very much.
Mr.
But what we arrived at, is that a stop?
That's a stop sign. Yeah, that's a
Okay,
stop. Sorry,
I'm
we're going to be real stringent with our red lights just because we have to do it in the little hearings as well as the big hearings, just for
Well, if you
consistency.
would have any questions about how it works, you just go ahead and ask.
Are there any questions from the committee? I think we were talking about Uniform Law Commission on the floor today, so everybody's quite familiar with it right now. So thank you for your testimony. Next proponent testifier. Welcome.
Thank you. My name is Steve Wilborn, STEVEWILLBORN. I'm a law professor at Nebraska and I'm a uniform law commissioner. But today I'm testifying as a citizen about a personal experience relevant to this. 40 years ago, I bought my first home in the country club area of Lincoln. Most of you are familiar with that, very nice area of Lincoln. I was provided the abstract for that, which I have. I don't know why I have it, but maybe they were digitizing at the time. And I noticed then, and I remembered it, that in the line of ownership, in the deed that was transferred in 1937, the first item mentioned is, no person of other than the Caucasian race shall be or become the grantee or lessee of said property, or except as a servant in the family living thereon, be granted the privilege of occupying the same. At the time, I was startled and appalled by that. I'm still startled and appalled by that. What this act would do would be to give me an option to disavow that statement in the land records. I don't know how common this is in Nebraska. There is a unit at UNO that's doing research on this that may be able to provide information later about how common it is. But this small example indicates to me that it was much more common than I ever would have expected before experiencing this myself. And thank you.
Thank you for your testimony. Are there questions for this testifier? Thank you so much for being here. Next proponent testifier. Anyone else who would like to testify in favor of this bill? Are there any opponents to this bill? Anyone in opposition of this bill? Anyone in the neutral capacity? Anyone who would like to testify neutral? Seeing no one, Senator John Cavanaugh, for the close.
Thank you, Vice Chair DeBoer, and thank you, members of the Judiciary Committee. And I just want to thank Mr. Ruth and Mr. Wilburn for being here and for working on this. And as you can tell by the lack of opposition, the lack of fiscal note, this is my third iteration of this bill, and I think we've got it this time. I think we figured it out. So I think unless you have any questions, I can let you guys go into your next hearing.
Oh, it seems like there's going to be some questions, Senator Cavanaugh. Senator Decay.
Thank you. Just a little bit of the history on it. How come it took 3 tries to get to the point we are now?
It's a great question, Senator Decay. Well, when I originally brought the bill, like I said earlier, I took it from Illinois and tried to match it to Nebraska. And, that makes it maybe not quite a perfect fit. And there was a cost associated with it to the counties that they opposed. And so then we took another swing to maybe make it work a little bit better for them. But fortunately, in the intervening time, the Uniform Law Commission was working on it themselves. And they came up with a solution that is different than mine, but more elegant. So this is not my idea and not my solution, but it is better than the one I proposed.
Thank you.
Senator Hopcroft.
So this would, thank you, Vice Chair. So this would replace LB 186 with the bill. Sorry, yes.
Yeah, I mean, if I would ask the committee to move this bill rather than 186 out of committee at this point in time.
Okay, and quick summary, what are the differences? I mean, the explanation you just gave, is that the main difference between 186 and this?
The
this bill?
biggest differences are 186 would strike the section of the deed entirely. This does preserve it in the historical record. And this has it's only got one cost, so it's a consent cost. Under 186, the county's complaints was more that they didn't know if a title was particularly long, it would actually cost them more to do it. And so this would be a consistent application of the costs.
Okay, thank you.
Thank you. Are there any other questions? Thank you, Senator Cavanaugh. There are no letters in support or opposition. I'll note for the record, and then we'll end our hearing on LB 914, and we'll move on to our hearing on LB 1119. That's Senator Dungan. Welcome.
Thank you. Good afternoon, Vice Chair DeBoer and Judiciary Committee members. I'm Senator George Dungan, G-E-D-U-N-G-A-N. I represent Legislative District 26 in Northeast Lincoln, and today I'm introducing LB 1119. LB 1119 is a relatively simple bill that prohibits homeowners associations from adopting or enforcing restrictive covenants regarding solar energy collectors. Existing prohibitions would be void and unenforceable. This bill would also provide a civil cause of action against any HOA or similar organization that violates this section. The motivation for bringing this legislation is born from the simple belief that homeowners should be able to do what they want with their property within reason. Installing solar energy collectors does not have a negative impact on neighboring properties. I introduced a similar bill last session, you might remember. We ran into a lot of roadblocks with that legislation, so we decided to start over with the language that was more direct and straightforward. Since introducing that bill last year, our office has received numerous calls from all over Nebraska on this issue. We heard from one South Lincoln resident being forced to remove solar panels at her own expense. This caused a lot of financial stress due to being a retiree on a fixed income. Most of our calls came from within the Omaha Metro. With the increasing benefits of solar energy, this issue will persist. This does not harm anyone or any single entity. It simply allows landowners to improve their property without infringement on the rights to personal property restricted by HOAs or other similar entities. I'm happy to answer any questions the committee might have, but I do believe there's some people behind me who probably have a little bit more personal experience with this, so I hope they would be able to testify about their experiences.
Are there any questions from the committee for Senator Dungan? I don't see any. We'll have our first proponent testifier, please.
Senator Wayne and members of the Judiciary Committee. My name is Deborah Nicholson, Nichholson. I am here to support LB 1119. Last year, I testified about the previous version of the bill, and I did support it. I did have a couple of reservations about specific provisions. Not anymore. This bill addresses all my concerns. I support LB 1119 because it guarantees homeowners the right to produce their own electricity, which they can use in their homes or sell to their public utility. By allowing solar installations in all neighborhoods, this bill is good for local economies. For example, getting solar for my home required upgrading my electrical service and panel, which cost $3,200. With the solar equipment and installation, I expect to spend approximately $20,000. If I do it this year, I can expect rebates from the federal government and LES. I hope to live in my house long enough to recoup my initial costs and enjoy free electricity well into the future. But if I sell my house before then, I expect to get back my investment as added value. According to CNET.com, 29 states and Washington, D.C. already have statutes that guarantee the right to solar access. Those states include our neighbors, Iowa, Missouri, and Colorado. Wyoming is not on their list, but another website, Palmetto, says Wyoming considers solar access to be a property right, so they don't have an additional provision. To summarize, adoption of LB 1119 shows respect for homeowners' property rights and their choices regarding use of their property. It offers homeowners the opportunity for long-term savings on energy. It leads to greater investment in our housing stock and more business for local electricians and solar installers who are so inclined to add to our supply of clean energy and increase reliability in our grid. Thank you.
Thank you. Any questions? Senator DeKay, followed by Senator Hogarth.
Thank you, Speaker Wayne. I was just wondering, you live in Lincoln area.
Yes, I do.
Would you have to be signing an agreement with like LES for retail wheeling because you're producing your own electricity? I know in the rural sector, you can only have retail wheeling up to 25 kW. So
I see. I know that LES is very supportive of private solar panels. I don't know about an agreement. I do understand that I can use what I need and then sell the remainder to LES. So I don't know specifically the answer to your question.
Senator Hogarth.
Thank you, Chairman. So are you restricted now from being solar panels on your house?
Personally, I don't believe I am. I live in a 1963 home, which predated solar panels, I think. I don't know that we have an active HOA.
Okay, so this bill, whether it passes or not, you could probably go ahead and do your solar panels, correct?
I'm going to do a little more research before I spend the money, but yes, I think so.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Welcome to your judiciary. How are you doing, sir?
Good, how are you?
Good.
Sir. My name is Al Davis, ALDAVIS. I'm here today representing the 3,000 members of the Nebraska chapter of Sierra Club in support of LB 1119. You have my handout, and I'll probably read most of what I have to say, but you could read it yourself. But multiple surveys over the past decade have indicated an increasing acceptance of solar and wind energy as the keys to building a sustainable future. Solar energy has become much more popular as the panels become more efficient, have more durability, and are so much cheaper than they once were. The solar industry is expanding rapidly and has largely been responsible for a flattening in the price of electricity over the past decade. Many bills have been introduced in this body to promote the industry, but few bills have been introduced to remove barriers to broaden consumer adaptation of solar energy. The opposition of proponents, the opposition to prohibit installation of solar panels by HOAs would be swept away if this bill becomes law. Solar panels on a roof are not an eyesore, but an adaptation to a new technology, which is helping our planet reduce the use of fossil fuels and should be encouraged rather than opposed by local and state governments. There is no evidence that solar panels depreciate the value of neighboring properties, contrary to what is sometimes claimed by the detractors. They do not detract from the overall appearance of a neighborhood, and they contribute to the grid by providing stability and distributed electrical services. On occasion, the stars lined up to offer real wins to homeowners. The Inflation Reduction Act is one example of that, providing Nebraska homeowners an opportunity to invest in the new energy economy by offering generous tax credits for solar panel installation on residential properties while at the same time lowering the homeowners' electrical bills. Injecting the new money into our state is boosting the state's revenue through increased sales and income taxes and provides good jobs for Nebraskans. Rooftop solar also offers our power providers additional energy generation during peak usage to reduce the need to burn additional fossil fuels. HOAs should be forbidden from standing in the way of this investment. We want to thank Senator Dungan for introducing LB 1119, urge the committee to send the bill to the floor for full debate. Just on a personal note, I live across the street from a development in Lincoln known as the Bridges, which is a very prestigious area. Several homes over in that neighborhood are putting solar panels in and have been doing so. So, the trend is there. We need to open the door so people can take advantage of it. Thank you.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Next proponent. Welcome.
Christy Eichhorn, EICHORN.
Right.
Chairperson Wayne and members of the Judiciary Committee, I'm here in support of LB 119. I don't live in a neighborhood that has a homeowners association. I'm here representing myself as a community and regional planner. I work with communities at the intersection of energy and land use planning. And during my outreach efforts, I often hear people suggest that we should use more roofs and less agricultural land for energy production. However, I believe that we need to strike a balance between the needs of both agricultural and urban property owners. We should not close the door on one sector and create problems for another. LB 119 allows for options and opportunities to promote a holistic approach to energy solutions that considers the interests of all stakeholders. Thank you.
Any questions from the committee? Seeing none, thank you for being here. Next proponent. Proponent. Seeing none, we'll go to opponents. Oh, are you a proponent? Yes, sir. Okay, come on, still on proponents. Go ahead.
Thank you so much. My name is Eric Hamilton Moyer. I'm a resident of Lincoln, Nebraska, 1220 Thunderbird. I have worked in the solar industry for the last 7 years and act as the residential operations manager for Nelnet Renewable Energy, but I'm here representing myself. Just suffice to say, these covenants, which are at times quite restrictive to the potential development of residential solar, in neighborhoods where we've encountered this and it has caused limitations as far as what can be constructed, obviously it's problematic. Finding homeowners that are interested in doing solar, they shouldn't be dissuaded, nor should they be punished for being able to, want to create something that benefits the community as well as reduces their reliance upon the grid. The biggest point that I would like to drive home, and really the focus of why I wanted to speak, is because on each project that we develop, I have 4 installers. These are full-time workers, 4 full-time employees that are Nebraska residents that work on every single project. We have 1 master electrician, a Nebraska resident, working on every single project. Each project employs a designer as well as an engineer. A certified engineer has to stamp the plan sets that we submit approval or permitting from the authority having jurisdiction, as well as to the electrical board to receive an electrical permit. We employ a lot of people. There's a lot of individuals with the utilities that we interact with that also employ a lot of people that have a hand in each of these projects, whether it's providing a witness test, a meter exchange, or the electrical inspectors that come out and inspect each individual project to ensure its compliance and safety. These are a lot of jobs, local people, local money. And it's to our benefit to allow that to continue and to remove barriers. Thank you.
Thank you. Any questions, Senator Decay?
Thank you, Speaker Wayne. Are there different types of solar panels rather than the big shields that we see mounted to the roofs or their
Certainly.
solar shingles that would lay down like shingles and still be absorbing the sunlight that would,
There are a number of different products that are on the market today that would mimic what a shingle looks like, more or less. It's not necessarily a roofing product per se. They're still solar panels. They just look like shingles. But
Yeah,
yes,
exactly.
there are alternatives that are out there. The one thing that I would note is that they're far less practical than a traditional individual shingles compared to a panel, for example. So for a shingle from a popular manufacturer, which I will not name, that is a solar panel, looks like a shingle, has an output capacity of 72 watts per shingle section. Okay. An individual solar panel at this point, just the typical run-of-the-mill installation, would have a wattage of 415 watts for a single panel. So for the amount of roof area available, you can accomplish a lot more with just a standard panel at this point.
with solar shingles, I'll call them.
Mhm.
Can they be laid on a roof of a house? So I guess the part of the roof that would be exposed to the sun to absorb it, you could use those shingles and then use a shingle that would look almost identical to them, regular shingles, so that you didn't have the cost in putting those on the roof.
Well, the issue there also comes down, you mentioned cost. When it comes to solar shingles, they're usually considerably more expensive than a traditional solar power system. That puts them out of reach for 99% of the homeowners that we would encounter.
I was just wondering if that would be more appeasable to an HOA or.
At some point, those might be viable. At this point in time, that is not my opinion that they are.
All right, thank you.
You're welcome.
Can you spell your name for the record?
Yes, sir. It's Eric, E-R-I-C, Hamilton, Hamilton, Moyer, M-O-Y-E-R.
Thank you. Any other questions from the committee?
I just have a clarification.
Senator Bosn?
Thanks. Can you tell me, how long have you been working in this space?
7 years.
Okay. Can you tell me approximately how many neighborhoods in the Lincoln area have HOAs that would exclude solar panels?
Off the top of my head, I can think of at least 2.
Okay. And, okay. You don't know how many houses are in those, so that's a tough question to answer, but they do exist in Lincoln.
Absolutely.
Thanks.
Thank you.
Any other questions? Seeing it, thank you for being here.
Thank you.
Any other proponents? Proponents? How about opponents? Opponents? Anybody testify in the neutral capacity?
Good afternoon, Senators. Excuse me. I'm here in opposition of this because it raises a few concerns as I was reading this and studying a little bit. And I know that some of the HOAs here in Lincoln provide the insurance for their buildings on the roofing and the structures of that. And my question is, does this bill address who would stand the insurance of that solar panel put on a particular house? Does the whole HOA have to absorb part of that? Because our insurance dues, our insurance our dues. So if I say, I don't really want that on my house, but my neighbor does, and it's okay with the HOA, which this law would say it was, do I have to help pay for his insurance of insuring his panel? Because I imagine there would want to be some insurance on those panels if you had a major event that would destroy them. And the other thing I would ask is, when we have a major weather event and roofs do need to be replaced, who is going to have to stand the cost of taking those panels off of the roof? Does the HOA and their insurance cover that? Or does the individual owner have to stand that put it on because he wanted that? I'm not against the energy saving and all of that, but I think we're bringing up some issues that need to be addressed either by you or someone that can give the HOAs the power to deal with these issues of the cost of the person or the HOA. So I guess that's my biggest concern right there. So thank you for your time.
Any questions from the committee? Senator Hobart.
Name?
Merlin Bartels, MERLIN BARTELS. I live here in Lincoln. Thank you.
Any other questions? See none. Thank you for being here today.
Thank you for your time, Senator.
Yep. Any other opponents? Anybody testifying in a neutral capacity? Senator, you want to close?
Sure. And just to be clear, was the last testifier neutral or opponent?
Opponent.
Okay.
He started getting up when I called.
Okay, my apologies. Just wanted to make sure. Colleagues, I think we've had a good conversation about this today. All things considered, I think that implementing this policy is a win-win-win. It allows individuals to protect their personal property rights. It also allows people to collect their own energy if they want. And I actually really appreciated the testimony with regard to the workforce issue and the job creation that comes out of this. And I think that's a really important point. I was contacted by a number of people last year when I introduced my earlier version of this bill, who had been directly affected by this issue. Where you see this come up probably most nefariously, whether it's intentional or not, is HOAs that don't outright prohibit solar panels, but can say, we're not going to approve improvements upon your home without a certain amount of votes of the HOA or something like that. So what ultimately ends up happening, and this has happened at least 2 or 3 times by people in Lincoln who called me, I don't have their names right now, is they think they're fine because the HOA doesn't specifically prohibit the solar panels. They install them, spend upwards of $5,000 to $10,000, and then they get a letter from the HOA saying, you got to take these out. And as the calls we got last year from people saying, now I have to spend literally thousands of dollars to take these down, or else I'm in trouble with my HOA from an HOA agreement that wasn't even clear in the first place that these were not going to be approved. So I think that's one of the problems. The other problem, obviously, is I just think the limitation on these is problematic from a policy standpoint, again, with regards to personal property. We changed this from last year by taking out a number of other provisions, right? So landlords can still prohibit solar panels from people who are leasing from them. We took that out. There were a number of other questionable provisions we took out. We really wanted to drill it down to what the actual problem here is. If you own your house outright, it's your home, and you just happen to be a part of an HOA, you should be able to do with it as you please. With regards to the testimony at the end there, or the witness at the end there talking about the insurance issue, my answer, I think, just off the top of my head, is that that's going to ultimately be up to the HOA, right? They can handle that how they see fit. But generally speaking, policies are going to cover their house or whatever improvements are on that. And if the HOA decides to try to cover some additional insurance with regards to their HOA fees, that would be up to them. I don't think that's something that we need to address in this legislation. I think individual HOAs have the statutory provisions currently in place to address those problems. This is getting at a totally separate issue where individuals are being prohibited from doing things with their property as they see fit. And I think that's something that's problematic. So I would appreciate your support of LB 1119, and I'm happy to try and answer any questions if anybody has some at this time.
Senator DeBoer.
Thank you. So when the last gentleman was talking, I was thinking about the fact that I used to live in a neighborhood until recently where we contracted together for our snow removal and our, things like that. It sounds like maybe there are some that contract together for their homeowners insurance, but it seems like that would be something that they could elucidate in their contract, that if you participate in this, then, it will not cover solar panels, blah, 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 blah. They could probably put that in that way. Does that seem right to you?
Yeah, nothing in this proposal would limit the HOA's ability to say, we're not agreeing to cover any additional insurance for improvements. They can handle that however they see fit. They just would be prohibited from outright saying you're banned from putting these on your property.
Okay. All right. Thank you.
Senator DeKay.
Thank you. living in rural Nebraska, I don't have to worry about HOAs. So just to understand a little bit, would this jeopardize the HOA's covenants at all as when it comes in regards to like shaker shingles compared to asphalt shingles or brick homes compared to wooden homes if homeowners are starting to pick and choose, or has that been addressed?
No, I don't believe so. The last thing that we're intending to do here is to dissolve HOAs or take away their authority in general to have those agreements with individuals who own the homes. This is a very limited and specific policy area that I think when we look at the overarching public policy, both of the benefits of solar panels and also the personal private rights or property rights, this is something that I think is worth legislating. But no, we're not going to be coming for individual, nitpicking what HOAs can and can't do in certain circumstances. And our statutes are pretty clear about what rights are afforded to HOAs and how they operate and what their governing structure is. So we're not modifying any of that. They can absolutely still exist and are free to contract with regards to snow removal or things like that. We just want to make sure they're not prohibiting what individual property owners can do on their house.
So you're fairly confident that this won't open up a can of worms going forward to have people do what they want to?
Yeah, I am fairly confident about that.
Thank you.
Any other questions? We have 25 letters, 19 in support, 5 in opposition, and 1 in neutral. And that'll close the hearing on 19.
Thank you.
Now we'll open the hearing on 11. That'll be 886, Senator Conrad.
Thank you, Chairman Wayne, members of the Judiciary Committee. My name is Danielle Conrad. That's DANIELLE Conrad, CONRAD. I am happy to introduce LB 886 today. 886 is about the interplay with homeowners associations, policies, or covenants that may restrict the ability of the homeowner to display a political sign for a candidate or issue of their choice. This is a bill idea that was brought to me by a constituent who lives in an HOA in my district in North Lincoln, and he's been perpetually frustrated with the ability to express his preferences for candidates during election times because of the restrictive nature of the covenants in the HOA that he lives within. When the idea for a bill came in, it really struck a chord with me, really resonated, because during my 8-year absence from the legislature when I was directing a civil rights organization, typically around election time, we would get a lot of intakes from Nebraskans all across the political spectrum who would kind of wake up and recognize some of these restrictions that it came to expressing their political preferences. And so I know from that experience as well that different states have moved directions, some prohibiting HOAs from putting these sort of restrictions on political speech, some leaving it to the local level, and then some having a prohibition as well. Since we introduced the legislation, I've also received a great deal of feedback from civil rights stakeholders who would like us to consider remove the time component in the legislation as proposed, as arbitrary and perhaps out of step with existing case law. And then I've heard from a lot of folks that live in apartment complexes in my district in particular. And we have one of the highest amount of residents that live in rentals in North Lincoln in the Fightin' 46. And they said, well, what about us too? What about us too at apartment complexes? So I said, well, I would definitely make sure to give voice to those ideas at the committee level. And if the committee is interested in moving a measure like this forward, I'd be happy to work with you on the technical aspects in relation to the time components or in terms of the overall application. But I think what's most important to remember about this measure is I really see it as having two quintessential key issues, key values, key liberties in it. The importance of private property and the importance of free expression. And this ensures that we honor both of those if we remove arbitrary restrictions. So happy to answer questions.
Senator Ford.
Thank you.
Yes.
It was, Senator Conrad, it was always my understanding that the Supreme Court had ruled on the ability to restrict this kind of First Amendment expression since it's political expression. Are you aware of that?
Are you talking about like the Reed case perhaps, or just a
Perhaps.
general long line of jurisprudence in regards recognizing
I
political?
assume you know more about that than me. So can you speak to what the Supreme Court has said about the ability to restrict political speech in that sort of way?
Sure. So in general, there's a pretty long line of case law that's consistently held that political is the type of speech that receives the highest protection because of its importance in our democracy. And so it should be subject to the least amount of restrictions possible, whether that's in the campaign finance realm, whether that's signage, whether that's speech on legislative floors or people criticizing our speech on the legislative floor, right? So generally, I think the Supreme Court has recognized or characterized the zenith or the apex in terms of, I guess, a speech hierarchy, so to speak. I'm not sure, and I will go back and triple check if there's been any specific case law on whether or not, from the Supreme Court anyway, whether or not HOAs can have restrictions in their covenants on political signage. There is kind of another track of First Amendment speech cases that are out there that aren't necessarily squared up in just political signs. But years ago, there was a case, I think it's the Reed case, that essentially was looking at a locality's restrictions about when they could put out this kind of sign to direct folks to their congregation. And the court basically really put a lot of restrictions on that kind of signage. There may be some examples for public safety, right? You don't want people to be blocking intersections and things like that, but I'm not sure if there's specific case law on point in regards to restrictive covenants and HOAs, but I think in general, the court has said political speech deserves the highest protection and signage restrictions are suspect.
So my understanding, or the folklore around wherever, is that the sort of restrictions that's put on political signs by maybe a city or an HOA or whatever would be unconstitutional as a violation of First Amendment. So that's the folklore that I have received from others.
Yes.
Is that is already sort of been decided. So I'm happy, I guess, to learn that maybe it hasn't been.
Yeah, I think you're right. I think that generally speaking, you're right. And so let me put this into practical terms. So at a restriction that you can put political signs up until like 60 days before the election or something like that. That would usually be kind of a local ordinance that would be out there. And as the case law continued to come down on the side of free expression, those kinds of restrictions essentially were struck down. Now, they weren't automatically repealed in all jurisdiction. And so from time to time, like when I was at ACLU, we'd get a call from, somebody in Eagle or somebody in Ainsworth or somebody in Lincoln saying, they want me to take my sign down. They have this old law in the books that says it's, too far beyond the election period. And we'd usually be able to knock that out pretty quickly with a call to the city manager or the county attorney or something like that. But I do think it's probably a gray enough area when it comes to the HOAs, because it's not exactly the government entity that's restricting your right to put up a sign, right? It's as a contracting party where you're the private homeowner that enters in that contract with that association voluntarily. So I think it may cut just a little bit differently there. Is that helpful?
Yeah, thank you.
Any other questions? Senator Decay.
Yes, I agree with a lot of what you're saying here. One
Great,
thing-
let's end there, right there.
Strike that from me. But I do have a question
Yeah.
about the timeline. It says, what I'm reading in my notes,
Yeah.
it says 90 days before they can go up up to 10 days after. Could that timeline be amended? That seems to me like I don't have a problem with the time before the election because there's a lot of campaigning going on.
Sure.
But the 10 days after, especially when you're walking 10, 12 steps to the sign, it shouldn't take, in my mind, it shouldn't take 10 days to remove the sign. Do you have a problem amending that?
No, thank you so much, Senator DeKay. And I would not like to see any time restriction on that, kind of similar to how we see it apply for governmental restrictions. But I would be happy to work with you and others to maybe tighten that up if we can, make it a little bit more manageable, strike the right balance. But, in terms of enforcement as well, in the last election cycle, and, the cool thing about political speech is it doesn't single out any one candidate or one point on the political spectrum, or it shouldn't, right? There were a fair amount of supporters of President Trump who, after he was unsuccessful in the last election, have continued to keep his yard signs up or fly his presidential campaign flag. So sometimes that show of political support can extend beyond the campaign period as well. And so we'll need to think carefully about not quashing political speech beyond just the parameters. Let's definitely keep talking, and I can see how other states handle it if they have a better frame on it.
Thank you.
Yes.
Any other questions? I see none. Thank you for being here.
Great, thanks.
First, we'll start with proponents. Proponents. Welcome.
Senator Wayne, members of the Judiciary Committee. My name is Grant Friedman, Grant Friedman, and I am here on behalf of the ACLU of Nebraska testifying in support of LB 886. The First Amendment and Article 1, Section 5 of the U.S. Constitution prohibit the government from encroaching on residents' right to free speech, which includes the right to speak in political and electoral issues. While private organizations like HOAs have the ability to regulate private property within their associations, they cannot disregard the free speech rights of their residents. Getting at the question that was asked earlier, the two Supreme Court cases on point are members of the City Council of Los Angeles v. Taxpayers of Vincent, where the Supreme Court held that public cities cannot regulate residents' rights to have property displays and political displays on their private property. The Reed v. Gilbert case held that the city cannot regulate public spaces such as in front of the courthouse or in front of the legislative building, that those spaces are all public and therefore allowed to have political displays. The only case to directly address the HOA issue of regulation is the New Jersey Supreme Court, which held that courts held HOAs violate the state free speech clause when they ban all political signs within their residential areas. At the ACLU, we have received numerous intakes regarding HOAs prohibiting individuals from displaying political signs on their property. We are grateful for Senator Conrad and Senator Blood for seeking to protect the rights of Nebraskans to state their political opinions under LB 886. This provides specific guidance to HOAs on the ability to regulate signs without interfering with the residents' free speech rights. By allocating the specific period of time a sign may be posted regarding either candidates or ballot measures, without restricting the more aesthetic methods HOAs seek to regulate HOA cohesiveness, LB 886 does well to protect the free speech rights of residents while maintaining the desire of HOAs to maintain their communities. For these reasons, the ACLU asked the Judiciary Committee to advance LB 886 to general file. I'm available for any questions.
Any questions from the committee? Seeing none, thank you for being here. Next proponent. Proponent. Next opponent. First, we'll start with opponents. Any opponent? Anybody testifying in a neutral capacity? Seeing none, Senator Conrad, would you like to close? Senator Conrad waives closing. We have 6 letters, 3 in support, 2 in opposition, and 1 in neutral. That'll close the hearing on LB 886. We open the hearing on LB 1268. Senator Conrad.
Thank you, Chair Wayne. Thank you, members of the committee. My name is Danielle Conrad. It's DANIELLE, Conrad, CONRAD, here today proudly representing the Fighting 46 Legislative District of North Lincoln. And I am happy to introduce LB 1268. Just very briefly, the legislature really last took up this issue in earnest during my previous service in the legislature, and last really opened up these statutes back in 2007. After talking with some members who at UNL Law School who have worked very diligently to engage in debtor defense and consumer rights, they brought this issue to my attention, and I know have discussed it with other members of the legislature, including Senator Bosn, who got up to speed on kind of where we are with this legislation and why we might need to make an update at this period in time. But basically, what this bill would do is that it would open up and amend Section 40-101, specifically addressing the homestead. The objective is to elevate the exemption from judgment liens and forced sales to $120,000 for individual residents. It's currently capped at $60,000. And again, that existing exemption has remained unchanged since 2007. So home values are on the rise, exponentially so. And this aspect of our law protecting homeowners who are working through some tough times hasn't really kept pace. And so I think it is a good time to bring this issue forward. I want to leave plenty of space and plenty of time for the law students and Professor Ruser, who will come behind me today, to talk about how this practice impacts low-income working families in their practice, and particularly elderly Nebraskans. So with that, I will stick around just in case there are any questions, but I think you'll enjoy hearing about kind of what's happening in the courts in regards to these issues with the current low exemption and why it needs to be updated.
Thank you.
Thanks.
Any questions from the committee? Seeing none, thank you. We'll start with proponents. Proponents? Proponents.
Members of the Judiciary Committee, my name is Alex Stanchus, ALECSTONCIUS, and I'm a senior certified law student with the Debtors Defense Clinic at the University of Nebraska. I'm testifying today in support of LB 1268 in my personal capacity, not on behalf of the University of Nebraska. LB 1268 is an update to the housing exemption against judgment liens from unsecured creditors. Currently, homes in Nebraska are exempt from judgment liens from unsecured creditors if the debtor's equity in the home does not exceed $60,000. This $60,000 figure was last updated in 2007 and was determined by taking the average home price in each county, adding those averages, and dividing the total by the total number of counties. Today, using the same formula, the average figure totals around $120,000. Our state should strive to incentivize investment in personal real estate. This outdated figure of $60,000 disincentivizes this investment. Under the current law, an individual with more than $60,000 in equity could have their home sold from underneath them for a $200 medical bill. In other words, a family could be forced to the streets while a debt collection agency profits. This is not only unfair to the individuals, but the costs of local government are significant. A 2007 study done by Congress estimated that the total cost of foreclosure is around $20,000, and that $20,000 is borne by local governments. Adjusted for inflation, these costs would amount to local governments potentially footing a bill of nearly $30,000. Most of these losses stem from unpaid property taxes, unpaid utility bills, and any cleanup or removal required after the property is foreclosed on. Furthermore, studies have shown that the long-term effects on families or individuals is that they are less likely to purchase a home in the future and more likely to default on future debts. All of this because of potentially small unsecured debt. Lastly, it's important to note that compared to rural states like Nebraska, this bill is still a conservative. For example, in neighboring states like Iowa and Kansas, the homestead exemption is unlimited. In Iowa, the purpose is to promote stability and independence among its citizens, and in Kansas, the justification is to prevent citizens from needing government aid. Today, I'm asking the committee to consider LB 1268 because it protects citizens from homelessness and the state itself from undue costs. I'm open for any questions.
Any questions from the committee? Senator Hybel.
Oh, that's fun. Thank you, Mr. Chairman. Do you have an idea of how many people in Nebraska take advantage of the homestead exemption?
We try to do a lot of research at the clinic. It's been difficult to kind of find figures. We've been working with the legislative research office to kind of find more concrete. We would imagine it impacts more elderly people who have more equity in their home. So
I think that's correct. Okay, thank you. Thank you, Mr. Chairman.
Any other questions? Seeing none, thank you for being here. Next proponent.
Good afternoon, members of the Judiciary Committee. My name is Matt Luty, Mattluty. I'm a senior certified law student with the Debtors Defense Clinic at the University of Nebraska. I'm testifying today in support of LB 1268. I appear today in my personal capacity and not in any capacity as a student representative of the University of Nebraska Law. LB 1268 would make two substantive changes to the current statutes that allow Nebraska homeowners to shield some of the equity in their homes from claims of unsecured creditors. In addition to raising the dollar amount of the homestead exemption, LB 1268 would clarify that each natural person residing in Nebraska could claim their homestead as exempt. This change would harmonize the homestead exemption statute with the provisions of the personal property exemption statutes made by the legislature in 1997. Amending the language of the homestead exemption to apply to all natural persons serves two purposes. First, as mentioned above, it harmonizes the homestead exemption language with the personal property exemption language. In 1997, the personal property exemption was amended so as to exempt the personal property of each natural person. This amendment, along with LB 964, which was passed in 2014, reflect the intent of the legislature to move away from the concept of family exemptions and replace them with individual exemptions. LB 1268 follows in that same vein by amending the homestead exemption to be available to each natural person. Second, LB 1268 will make entitled to receive the exemption. As the homestead exemption is currently written, an unmarried couple could effectively receive a $120,000 exemption, whereas a married couple would only be entitled to a $60,000 exemption. In effect, the statute punishes couples for getting married. It seems highly unlikely that it was the intent of our legislature to give a larger exemption to unmarried couples than to married couples. LB 1268 would allow married couples to claim the same amount of exemptions as an unmarried couple who live together. Thank you.
Any questions from the committee? Seeing none, thank you for being here. Oh, Senator Bosn has a question.
Can I just have you clarify that? So what you're saying that the current statute says is that my husband and I would be preempted from each of us applying for this, even though we jointly own the home.
That has been the experience of married couples who have tried to claim this exemption, yes.
Okay, so under the current law, essentially I'd be entitled to $30,000 and he'd be entitled to a $30,000 jointly. Our home, we would be exempt for the $60,000 together.
Correct.
And how did you get to a $120,000 exemption? Can you explain that to me then?
Yes, so under the current statute, in effect, each individual can claim $60,000. So an unmarried couple who live together, as opposed to a married couple who live together, the unmarried couple as individuals can each claim the full $60,000 exemption, in total giving them a $120,000 exemption as a couple. Whereas a married couple has only been able to claim $60,000 as written in the statute.
Okay, so then essentially if we change this, am I understanding that if we increase the amount and clarify that each person in the household, married or otherwise, qualifies, we would be then at the, now I'm forgetting where I'm at with the, what is the amount we're changing this to, 120?
Correct.
It would still be 120 whether my husband and I are married or whether my husband and I are unmarried.
That's correct, yes.
So the cap of the house would be $120,000, or would the cap of the house be $240,000 in that circumstance?
I believe the cap would effectually be $240,000 then.
Okay, so essentially, we're changing this, really what we're changing is the requirement that the individuals be married or not married.
I'm sorry.
Increasing the amount for married individuals, the amount doesn't just go from 60,000 to 120,000. For a married couple, the amount goes from 60,000 to 240. And unmarried couples, it goes from 60,000 to 120,000.
For an unmarried couple, yes, it would go from 60,000 to 120,000 each. And for a married couple, yes, it would be what is effectively $30,000 to $120,000 each.
Okay, that's right. That's a better way to say that. Thank you.
Thank you.
Next program.
Thank you, members of the committee. My name is Kevin Ruser, Kevin Ruser, testifying today in support of LB 1268. I'm here in my personal capacity, not as a representative of the University of Nebraska. I grew up on a farm near Grant, Nebraska, and I've been practicing law since 1979. During my time as a practicing lawyer, I've represented exclusively low-income clients. From 1979 to 1985, I worked with legal aid in Grand Island first and then Scotts Bluff. And since the mid-1980s, I've worked with law students at the College of Law representing low-income clients. LB 1268 would make two salutary changes to the statutes that allow Nebraska homeowners to shield some of their equity in their homes from the claims of unsecured creditors. Most basically, it would update the amount of the homestead exemption that was last established in 2007. And relatedly, it would resolve an ambiguity that resulted in the 2007 amendments that would clarify that each natural person residing in Nebraska could claim their homestead as exempt. This would harmonize the homestead exemption statutes with the personal property exemption statutes, which were amended to read like that in 1997. I also have a couple of other observations that I think recommend the bill. First of all, just to be clear, this only applies to unsecured debt. It wouldn't affect the rights of secured creditors. So in other words, anyone holding a mortgage or a trust deed on a property wouldn't be affected by this bill. And second, to echo what you've heard already, it's my experience during my time in practice that the population most at risk of losing their homes to unsecured debt are elderly homeowners, because by and large, they have the most equity in their homes. They've spent their lives paying down their mortgages and building home equity. Many of them are in fixed incomes and they have trouble servicing debt. And so it would be nice to have a little more help for them to protect the equity that they've spent their lifetime building. And with that, I'm happy to answer any questions.
Questions, Senator DeBoer?
Thank you. So I also was a little confused before. I thought I had, then after the questions, now I'm a little more confused again. So currently it's 60,000 each. So, but if you're married, you count kind of as one person.
It's 60,000 per homestead,
So-
right? And so this comes from what happened back, and you're going to hear some other people talk about it, who probably more about it than I do, because they work in this field every day. But originally, the homestead exemption could only be claimed by the head of a family, right? The head of household, which in the old days was the man, right? So it was limited to the homestead rather than, right? Each individual might have an interest in, depending, it might be a joint tenancy, or it might be a tenancy in common. But whatever their interest is, what this bill would do is harmonize it with the personal property exemption statute, saying whatever each individual's ownership interest is in their home, they could exempt up to a total of $120,000. So to address Senator Bosn's point, yes, if there are two people and they each own 100% of the property, they could each, under these amendments, claim $120,000, right? It could be a joint debt, or it could be debts against the individual homeowner. But each natural person having equity up to $120,000 in the homestead, in their homestead, would be able to claim that amount of equity as exempt.
So if there were three persons that owned a home together in joint tenancy, then all three would get it and it would go up to,
If there was a judgment jointly against all three, yes.
okay,
But that's the key. Who's the
Yeah.
judgment against? Right.
thank you.
Sarah,
Thank you, Mr. Chair. Can you just clarify one thing for me? I was under the impression that depending on the average assessment per county, that had some bearing on how much the homestead exemption.
I think you're thinking of the homestead tax exemption as opposed to the homestead exemption to shield it from a debt collection.
Okay,
Yeah.
thank you, thank you. Thank you, Mr. Chair.
any other questions?
Can I call on?
Senator Bosn?
Thank you. Professor Bruiser, can you explain then, I guess the concern that I have a little bit piggybacking off of what Senator DeBoer said with multiple, more than two owners, is now that equity will almost certainly exceed, what if you had six co-owners of the home? The value of the house, or not certainly, but could very quickly exceed the value of the home. And I think that creates its own, now we're putting a Band-Aid on a problem that we created by trying to protect that class. So how do we fix that?
So with all due respect, you sound a little bit like a law professor, Senator Bosn. I think you're spinning hypotheticals that may not actually exist in reality. But to answer your question, yes, that is something. I mean, to be clear, that's what this would do. I really wonder how often that would happen in practice. That's my response.
Thank you, I think.
You're welcome.
Any other questions? Seeing none, thank you for being here. Next proponent. Go ahead, Tim.
Good afternoon. My name is Sam. That's Turco. I am a bankruptcy attorney practicing throughout the state of Nebraska. I've practiced law since 1992. Day and every week in my practice. I meet clients in every county of this state. Bankruptcy is a practice where, there's two judges for the whole state. We deal with every type of family, every small business, every individual. This problem keeps coming up, especially since the skyrocketing house prices that were lit off by the COVID virus. Home prices, as we all know, have just escalated. Recently, I dealt with a client in Omaha, a retired woman who lives in the Florence Boulevard neighborhood of Omaha. Her home in 2018 had an assessed value of $26,200. Currently has an assessed value of $98,400, gone up $70,200 since 2018. I meet these people on fixed income, retired people who have always paid their bills, but with medical bills and insurance claims, very often they wind up deeply in debt. Normally those people, we would have an option of taking them, if needed, into a Chapter 7 bankruptcy to clear these debts. But on a weekly basis, when I talk to these people, the first question I ask them is, what is the address of their home? How much do they owe on the mortgage? And I type their address into the internet to see what valuations I see on websites like Zillow or Realtor.com. And these people are shocked
to find that their home values have escalated $50,000, $60,000, $70,000 in the last 3 to 4 years. And I cannot protect their home in a Chapter 7 bankruptcy. Just doesn't cut it. And so the option is we have to tell these people they can't go into a Chapter 7. Rather, they have to opt for the expensive Chapter 13 case. You know, an amount of money equal to what we can't exempt. And so senior citizens, people on disability who are in this situation are forced into payment plans that are difficult to afford, and sometimes they're not affordable.
Thank you. So let me see if there's any questions. Can you wrap up your final thoughts?
That's the first issue that this statute addresses very well. It says, look, 60,000, which that change occurred in 2014. And in 2014, the legislature increased that exemption to 60,000. And I think we all thought that was a very decent level. In the last 4 years, that changed. Okay? And we're just meeting people that shouldn't be in the 3 to 5 year payment plans who are now forced into it.
Thank you. Any questions? Senator DeBoer.
So the discussion that we were having earlier, Senator Bosn and I put some hypotheticals forward if there were 3, if there were 6, if there were some number of people. How often do you see a situation where there are 3 or 4 people who own a home and then are also in debt together?
Almost never do you see 3 to 4. What is common, though, is that the married couple, so you have 2 owners of the house, or an unmarried couple, and there is a judgment against one owners but not the other. And this kind of comes into the second part of this statute, which is absolutely critical. The current statute, prior to 2014, before we increased it to 60,000, it was very clear the homestead only was given to either married couples or individuals who were head of household. They had dependent children. It was not available to single people without children and dependents. Well, in 2014, we updated our law to say that that's kind of not representative of what we want to do. We're going to give that homestead exemption to everybody, whether you're single, whether you're married, whether you have children, whether you're...
Sorry.
And that was a good change in the law. But it also introduced tremendous confusion into our statute. And the confusion is, okay, so now an individual gets a $60,000 homestead, and they changed the part of the law that addressed individual unmarried people. But it didn't address the issue about what about married people? Do they get 60,000 per, husband, wife? Or are they just getting 60? And it's a very confusing issue. We are litigating that issue on our firm. We had a hearing just this past Monday in the United States Bankruptcy Court where we are challenging what this law means. And we're asking our court to rule on that issue. Do married couples each get a $60,000 exemption, or are they limited to one $60,000 exemption? We spent nearly an hour with Judge Cruz in the bankruptcy court going over this issue. And everybody in the room is intelligent, is well-read, they understand the issue. We don't know the answer. And I have stared at this statute for hour after hour after hour, and I don't know the answer because it's just one of those things where we changed something in the law in 2014, but we really didn't think about what that means to the other parts of the law. And so intelligent people on both sides are coming up with opposite answers. And so when people call me every week to say, is my home protected? And they're a couple, they're a married couple, and they have more than 60,000 of equity, I say, I don't know. I don't know the answer. I've been doing this for 30 years. I should know the answer. And this statute gives us the answer. It says it very clearly. So whether you think we should go from 60,000 to 120,000 per individual for the exemption, what is absolutely clear, if we need to answer this, what does a married couple get? Because I cannot believe that this legislature in 2014 had the intention of saying that an unmarried couple who own a house together, they can each claim a $60,000 exemption, and they get 120 couple. I can't believe this legislature ever had that intention. But when you read the statute, we just don't know. And when judges read a statute, they're very conservative. You know, their attitude generally is if there's something that's not clear, let the legislature, make it clear. So that's why I'm here. Let's make it clear. And I just don't think, I can't imagine we'd say, well, if you're not married, you get 120,000, but if you're married, you only get 60. I know that's the one answer that doesn't make sense. And so on a simple sense of fairness between unmarried couples and married couples, the rules should be the same. So,
Thank you.
Senator Black.
Thank you, Senator Wayne. I just have a really quick question. Based on your experience, because this helps us in the future when we go to pass more legislation, what would you say is the number one reason that young families in Nebraska have to claim bankruptcy?
what is the
The number one reason why you think that young Nebraskans?
number one reason and research after, nationwide research that's gone on for years, medical. Because medical debt turns into credit card debt. And so people file cases and it's mostly credit card, but it's credit cards because of medical.
Right.
And there are other reasons. Family breakups are a major issue. Factories closing down can be a major issue. And we've dealt in Nebraska with our manufacturing jobs disappearing quite frequently. I'm kind of remembering the Vice Grip factory and I think Beatrice closing down. And so we get waves that come in. And in 2008, mortgage meltdown crisis was just huge. But year after year, week after week, the number one thing that comes in is to be medical. And even people with health insurance, it's confusing. They don't know how to respond when the insurance company doesn't pay the claim. I had a client whose husband had heart issues and he was constantly, his heart would be stopping. They'd call emergency and the emergency people came out and said he has to go on a helicopter, and they flew him to the hospital, and unfortunately he passed away. They send in a claim for a $30,000 helicopter ride. The insurance company denied it, saying it wasn't necessary because he died. It wasn't necessary. And my client tells me this, and I said, that's wrong. It's not like when they come out, you have an option. It's like they tell you he's going on a helicopter. Appeal that denial. And she did, and the insurance company paid it. And I think the insurance companies deny a lot of claims just to see if we respond. And from a business standpoint, I guess I understand that. But it's a complicated system. There's confusion on how to file claims. There's confusion on what to do when they're denied. I had a client who worked in Omaha. He had health insurance that covered Omaha doctors. He's delivering a machine in Norfolk, Nebraska, and he decides to have a heart attack. And the insurance company denied his claim for $50,000, saying that's out of network. And I sit down with them. I said, "That's not true." It's like there's no such thing as out of network for emergency medical services. They wrongly denied your claim, but it was too late to appeal. And when he comes to me, there's judgments, there's garnishments. He can't pay his rent, and so we have to go in and clear up the debt. And so medical is the number one thing, and there's many factors, but that's always number one.
Any other questions from the committee? Seeing that, thank you for being here. Thank you for your testimony. Next, proponent.
Good afternoon, Paul Ray, Paulrea. Like my colleague, Mr. Tierker was actually a classmate of mine in law school. We both have been bankruptcy attorneys for over 31 years. I pretty much am the cleanup, I hope, to answer any last questions or anything that have come to mind to the senators here today. I can only reiterate, it's just a question of public policy of whether or not we're going to allow certain debtors to be allowed to keep a certain amount of real estate, even though they may owe money to their various creditors. I think everyone before me has pretty much well stated anything I was going to state. Does the committee and or any of you have any questions?
Any questions from the committee? Seeing none, no, thank you for being here. Next proponent. Now we'll switch to opponents. Neutral testifiers. All right. Any closing thoughts, Senator Cavanaugh? There are two letters, one in support and one in opposition, and that'll close the hearing on LB 1268. And that'll close today's. Next, we'll go to LB 1220, Senator Bosn.
You lied once on the coloring, so I'm not asking you working for me.
Welcome to your committee.
Thank you, Chairman Wayne, and good afternoon, members of the Judiciary Committee. For the record, my name is Carolyn Bosn, CarolynBosn. I represent District 25, which consists of Southeast Lincoln, Lancaster County, including Bennett. LB 1220 is on behalf of attorneys from the Nebraska State Bar Association's Real Estate, Probate, and Trust section to update and clarify provisions of Nebraska statutes that govern a person's ability to manage and transfer their property in the event of a death or an incapacity, and in planning for the event of their death or incapacity. This bill makes a number of minor changes meant to modernize and update provisions of statute that estate planners have identified in assisting their clients. I'll go section by section. First, section inconsistency in statute by providing explicit authority for a person 18 years of age or older to waive bond on their own behalf when a personal representative is appointed to manage an estate of which the 18-year-old is a beneficiary. Under existing statute, an 18-year-old has an explicit authority to a personal representative to manage an estate, but does not have clear statutory authority to waive the bond requirement for personal representatives. This comes up in situations, for example, when one parent dies and the child is 18 years of age. The 18-year-old can nominate the surviving parent to serve as the personal representative, but cannot waive the bond requirement on their own behalf. Because such explicit authority does not exist, it has caused inconsistency across the state, as some jurisdictions will allow it on their own, while others will deny it, requiring the bond then. Moving to section 2. Section 2 increases the threshold for the value of real property for which a small estate affidavit can be used in lieu of the need to use probate for transfers of real property from the existing value threshold of $50,000 to $100,000. In 2022, the Nebraska statutes were amended by the passage of LB 1124 to increase the threshold for transfers of personal property by affidavit. So personal property in that bill went from 50,000 to 100,000. That's in Nebraska Revised Statutes, sections 30-24-125. Even so, the statute still provides that real property instead of personal property may not be transferred by affidavit unless it is valued at $50,000. This inconsistency causes confusion and serves no real purpose. Section 2 of this bill would increase the real property value to mirror the value of applied to personal property. So they would be the same, both at $100,000 when using an affidavit, and is consistent with the increase in the exemption amount that the legislature adopted in 2021 in Legislative Bill 310 with respect to inheritance tax for first-class relatives. Moving on, sections 3 and sections 9 serve to update the amount of money that can be transferred directly to a minor without the need to establish a conservatorship or a trust. Under the Uniform Transfers to Minors Act, section 43-2707, subsection 3, limits a transfer to a minor to not exceed $10,000 without a court order. That limit has been the same since 1992. Nebraska statute sets the facility of payment to a minor in chapter 43-2707 at $25,000 annually, and that amount has not increased since 2006. Attorneys believe that the inconsistency in the amounts in these two statutes is unnecessary and confusing, and that the amount should be increased for both. For example, Iowa recently raised its limit to $50,000. Additionally, inflation, when counting for inflation since 2006, would bring that amount to $25,000 to almost $37,600. This bill proposed that the amount would be increased to $40,000. Moving to section 4, this addresses an inconsistency in Nebraska law in a situation in which a person becomes incapacitated and a conservatorship is sought. Under current statute, if a guardianship is established, the person has an express statutory ability to hire an attorney for the purpose of challenging the establishment of a guardianship. However, no such similar provision exists in instances in which a conservatorship is sought. Section 4 takes the language included in the guardianship statutes and provides that the same would be language would be applied to conservatorships in chapter 30, section 2537. Moving to section, and just for clarification, because there was some question about this, guardian is a person who's appointed to make personal decisions for protected persons. Think decisions such as where to live, medical decisions, and education, whereas a conservatorship is more specifically tailored towards having someone who can make financial decisions for that protected person. Sections 5, 7, and 8 include an update to the probate code considered by this committee in Senator Ballard's LB 549 from last session. Nebraska law presently authorizes an 18-year-old to establish a will. However, the statutes that deal with other important estate planning mechanisms like trusts and powers of attorney reference the need for a person to have, quote, capacity to execute those documents. This causes practitioners issues as they advise clients who may be leaving home to attend college out of state or for some other reason need those types of planning documents. Finally, section 6 clarifies language in statute that provides for the optional registration of a trust. Current law allows for such registration but makes it optional. Nevertheless, the title to the statute as pulled from the Uniform Trust Code references a duty to register. Since no technical duty exists, a provision is added to clarify that registration is not required to establish the court's jurisdiction. A clarifying provision is also added to address how registration might occur in the instance in which there are co-trustees appointed. Thank you for your time and attention. I would be happy to try to answer any questions. And Tim Haruza with the Bar Association will be following me and may be more qualified to answer detailed questions.
Thank you. Any questions, everyone?
This isn't a question. I'm just going to comment and say I'm very, very pleased to see that you've taken over the esoteric death bills for me and I don't have to do them this year. So thank you for bringing these.
Okay.
Maybe.
I have some questions. Why are we going with 18 versus 19, which is the age of majority in Nebraska?
Are you talking about the section 6?
Yeah.
I believe Tim Haruza would probably be better able to answer that question. Can I defer that question to him?
No, I was asking you.
I don't know the exact answer.
That's fine. Thank you. Any other questions? Seeing none, thank you for being here. Can you waive closing? Appreciate that.
Efficiency at its finest.
First proponent.
Good afternoon, Chairman Wayne, members of the Judiciary Committee. My name is Tim Haruza, last name spelled H-R-U-Z-A, appearing today on behalf of the Nebraska State Bar Association. Let me first start by thanking Senator Bosn for introducing LB 1220. The intro that she read does outline each of the sections of the bill that deal with a pretty comprehensive update from estate planners on provisions in Chapter 30. There is one stray provision from 43 that crosses over and deals with how we handle giving property or money to minors in certain instances. Maybe I'll just start by answering Senator Wayne's question. The reason that those portions of the bill deal with 18 years of age instead of 19, general age of consent in Nebraska is 19. Our Wills Act that currently exists allows clear authority for an 18-year-old to do it. The sections that deal with trusts from the Uniform Trust Code, which hasn't been updated broadly since the 80s or 90s, whenever that was adopted, reference capacity instead of an actual age. They don't reference an age of majority. They don't reference 18, whereas that's specifically stated in wills. What that results in is an 18-year-old can do a will before they go off to college, but they can't right now execute a power of attorney or a living will for like healthcare or something like that. And so our position has been it should be consistent and clear, because those are typically documents that you do when you're planning for an estate. This comes up, you have an 18-year-old in Texas. The one example I've heard is like they go to the hospital and need care. A power of attorney that's not recognized or authorized under this statute because they're 18 years of age wouldn't be acceptable to help provide them care. So you get some weird loopholes that happen, and attorneys just want to make sure that there's consistency in that age for estate planning purposes. With that, I'm happy to answer any other questions about pieces of the bill that you might have.
Any questions? So in one of the sections, it talks about after the appointment, the protected person may retain an attorney.
Yes.
Doesn't the court already have to appoint one if they challenge? It's a constitutional right.
And so what the instance that we've run into is that, at least on the guardianship side, the language that's in here, we took the word, we just changed it to protected person to refer to a guardianship or to a conservatorship instead of a guardianship. Problem that you have is the conservatorship is a more limited restriction and ability, right? So if you got a guardianship, it's all of your choices. There's clear authority in that statute, which is word for word what this is. On the conservatorship side, though, there's nothing akin to that. So, we've had two attorneys that have given us examples of how conservatorship is entered, the client comes in and wants to hire the lawyer to help them avoid that or to combat that. They don't technically have the ability in court. So all this would do is just give clear authority for the lawyer to take that hiring and know that they'll eventually get paid, right? And that person has capacity for that purpose to hire a lawyer in their own instance. To your question about appointment, sometimes the GAL gets appointed. There's some inconsistency there as I understand it, but.
No, I'm saying if the protected person wants to challenge a guardianship or a conservatorship, that is a constitutional right that a judge has to appoint counsel, or that's appealable. So I don't know why the language is needed, I guess is my point.
You probably know more about it than I do in terms of that. Like I said, I think the issue that we're looking for resolving is just making sure that there's no question if that person wants to hire a private attorney, that the lawyer can do that, right? Once the conservatorship order is issued, I don't have the ability to enter into contract on my own. My conservator would have to do that on my behalf. But if the conservator says, look, I'm not going to pay your attorney to challenge whether I can handle your financial stuff, I'm kind of in a limbo here on what I can and can't do.
Okay. Any other questions? Seeing none, thank you.
Thank you.
Any other proponents? Any opponents? Anybody testifying in neutral capacity? Senator Bosn, would you like to close? Senator Bosn waives closing. There are no letters in opposition or support, and that closes the hearing on LB 1220 and today's hearings. Thanks.